Thank you everyone for joining us today for our webinar where we discuss a variety of topics from the perspective of an estate planning attorney, a CPA, and a financial advisor. Today, we'll be discussing practical steps to take after the death of a loved one. I think this is a really important topic. It's something that many of us have dealt with or will have to deal with, but it's not something that's really discussed a lot. So hopefully you'll learn a few things today that will help you in the future. Presenting today will be Donna Lee, a certified financial planner located in the city of Orange. I'm Yuri Yu, a CPA located in Fullerton, and you'll be hearing most from Sophia Kim Sakamoto, an estate planning, probate, and living trust attorney. She has offices in Buena Park and Mission Viejo. If you have any questions during the webinar, please type them in the chat box and we'll do our best to answer them at the end, time permitting. Please note that this webinar is being recorded. The presentation contains general information. No legal or tax advice is being provided, and no attorney-client relationship is established by this presentation. This presentation and the materials are copyrighted, so please don't take any screenshots without prior permission. A recording of the webinar will be available for viewing online within a week or two. So our agenda is here. As you can see, there is a lot to cover today, so let's just get started. Sophia, I'll hand it over to you.
Thanks, Yuri. Thanks everyone for joining me today on a very important topic. I tried to gather all the questions that people frequently ask me as an estate planning and probate attorney. And also, I think these are just things that you need to know, and it's generally not talked about. So I think this will be an important presentation. Just want to remind you, it's not comprehensive, right? It's too much to put into just a 45-minute presentation. Definitely not legal advice. It's just general information. It's based on California law for this year, 2022. It's going to be a lot of information. I don't expect you to know everything, but if you can just issue spot, it's like, oh, I thought I heard something about that. I mean, knowing is half the battle. So let's just get right into it. Oh my gosh, mortuary, right? So obviously if there is a death, then what's going to happen, right? With the body. Sometimes there's a question of, do we bury the body? Is it going to be cremated? It would help if there was an advanced healthcare directive. This document appoints an agent, a point person. This point person will be able to make these decisions, talk with the mortuary, talk with doctors, anywhere else that needs to make these decisions. It's important because what if your whole family is disagreeing about what to do? Mom wants to bury bodies, husband wants to cremate. Who gets to make that decision? Well, the Advanced Healthcare Directive also sets a priority list of who will make those decisions. The mortuary usually tells Social Security and, of course, Medicare and Medi-Cal about the death. A death cannot be reported online, and you can't apply for survivor's benefits online either. So if you do want the mortuary to make that notification, you need to provide them with a Social Security number. With Social Security, the survivor usually gets a lump sum payment. It's around $255. And of course, there's so many different provisions about the amount of benefits. I guess the most general one is that if you are a widow or widower, and if the person who passed is full retirement age or older, you get 100% of the deceased worker's benefit. Of course, there's limits on how much a survivor can earn for these benefits. And there's also some requirements, like what if you get remarried? It depends on if you are age 60 before or after this remarriage. So all of those things can affect Social Security benefits. Also, just wanting to let you know, if you had a family member who passed from COVID, FEMA also has funeral assistance. So if you know someone who passed from that, maybe just letting the family know that they can get some funeral assistance from FEMA. You have to make an application. But going back to this, once Social Security learns about the death, usually they will automatically return any payments that were made before the death. I'm sorry, after the death. they will freeze that account. So usually it's by direct deposit. They'll take it right out of that same account. If there was a bank account that with only that deceased person's name, it will be frozen. So once the bank, gets that notification from Social Security and they take the money out, they usually freeze that account for 40 days and until a death certificate is issued. Usually in LA County right now, it's taking about 2 months. I think OC is a little bit sooner, but it's taking some time now to even get a death certificate. If you have like a joint account, obviously there's another person on that name, on that account, so it will not be frozen, but it only for accounts with just that one person's name. As you know, funeral gets really expensive, typically, $5,000 to $20,000, right? It's very expensive. Sometimes I recommend prepaid funeral insurance as an option for those who are thinking about maybe doing some planning before. As Donna could tell you, the funeral insurance may or may not be the most like investment savvy thing to do. But with funeral insurance, you get to pick out the casket, the vault, the funeral home. You can make all these decisions beforehand so that when the time comes, it's just easier for your family to, they just, make a phone call and then everything's already decided. So sometimes that alone is worth it to get this prepaid funeral insurance. But now going into bank accounts, because this is also something, what happens to your bank account if, a family member passes away? Do I have access to that? How do I get the money, right? If there is a bank account with a joint owner, so usually like husband and wife, or you could have it with whoever, a joint accountant, the surviving joint account holder usually goes to the bank, they have a death certificate, and then this account now belongs to the survivor. Keep in mind, if anything is joint, it doesn't matter what the will or the trust says, whoever's the joint account holder, that's how it goes. Of course, there's exceptions, but generally. And this can sometimes disrupt your planning. Some people may not realize that, if I have someone as a joint, it automatically goes to that other person. It's not going to go through my will or trust like how I planned. So if you are already saying, my 3 kids get things equally, but then you've got a bank account with that one child's name on it, they'll obviously get a little bit more. Something that always happens, or that I hear a lot with my clients is, I'm going to put oldest daughter as a joint account holder. If something happens to me, they'll know what to do, right? Which in the parent's mind is like split it 3 ways. But when that actually happens, then daughter's like, I took care of mom and dad. So, this is like compensation for me. And they generally, may or may not distribute it to their siblings, right? So if you do have a joint account, just know that that money goes to the one holder. And then it's up to them about what to do with those funds. Is the account only in one person's name, the one who passed? If that's the case, then now they're not here. Who's going to have access to this account? If the assets that are in these accounts, could be 1, it could be like 10, it could be more. If they total over $184,500 together, total, that's the new amount for this year, then all the assets have to go through probate court, because the banks will not release that money to just anyone, right? It's like, I'm an heir, right? How are they going to know? They will want a court order, and that court order is probate. And banks will not unfreeze that account until you have this court order. If it's less than that amount, then usually the next of kin will need to sign an affidavit and present it to the bank. It's a small estate affidavit. Usually there's no probate. Sometimes clients ask me, well, if they're all at different banks, like how do they know? And you're right, maybe they won't know, but at the same time, this affidavit says you're making a declaration under penalty of perjury that those assets together do not exceed $184,000. If there is a will, the will is probably going to say who's in charge and who gets the assets. So it could be the next of kin, or the will says, no, it just goes to my, one daughter, not all 5, so it could be whoever you want it to go to. There's also something called a TOD, which is a transfer on death. So if you have a bank account right now and maybe it's a small account and you're just like, I don't want this joint account holder to have access now, but I just want them to get the money after I'm not here, then maybe you can ask the bank to assign a transfer on death beneficiary. So this means that while I'm alive, it's my account, I have all control, but only when I'm not here, then it goes to the next beneficiary. If you have a trust, you could also make the trust the beneficiary. And then is the account in the name of a trust, right? So that's good, because if something happens to you, then whoever is the next trustee, they just go to the bank. They can immediately have access to the account. They don't have to wait the 40 days. They just need the death certificate and a copy of the trust terms to say, hey, I'm the next in line. Then they have, all the rights and powers that the previous owner had as the trustee, and they can use that in accordance with the trust terms and use that to, pay last expenses, taxes, expenses, funeral, and make distributions. When it comes to investments, insurance, retirement accounts, of course, there's a lot of different rules that apply. But for the most part, when naming a beneficiary, the proceeds go directly to who is named, regardless of, again, who's on the will or the trust. So you may want to think about this when you're planning like a will, or, okay, they're going to get this investment account plus, you may want to consider that. Sometimes as a strategy, you may want to consider different assets to be part of the trust, and maybe some things have different beneficiaries than the trust. The beneficiary should call the company and submit the claim form with the death certificate. That's how they make a claim to get the proceeds out and to them. You could also name the trust as a beneficiary, which is important if you might have children who are under 18. Obviously, they're 18, so under 18, they're minors. They cannot sign anything. They can't handle money. So sometimes if you have a trust, the proceeds are paid to the trust. The trustee manages it for the child until they reach certain ages. And speaking of which, again, if a child is under 18, then they can't handle anything. So if you do name someone who's under 18, then what could happen is a guardianship court might need to get involved and manage those proceeds or assets until the child reaches age 18. Sometimes there's no beneficiary on a policy. And really it depends on the company, right? Or the policy, what did you have before then? Did the policy say it goes to the next of kin? Did it say that, if you have 3 people and one's not there, does it go to the other 2, or does it go to their kids? Or maybe if nobody's there, does it go to the estate of this person who passed? Or does it go to the estate of the person who set up this insurance, right? A lot of questions. But if the situation is that there's no beneficiary and it has to go to probate, again, if the proceeds are over $184,000, it might have to go through that court process, because only the court can decide where it goes.
Can I jump in a little bit, Sophia, here?
Mm-hmm.
So beneficiary it's like one tiny question on an application. When you open an account, there's always pages and pages of application, and there's one question on there for beneficiary. So it's very easily overlooked or minimized or trivialized. But this is actually an area that has huge planning opportunity. So it depends on the type of account. The rules are different depending on the type of account it is, how it's titled, who should be listed as the beneficiary. So for investments, if you have a named person, right? Let's say it's my own investment account and I name it to be my husband, for example, then he's going to get the money regardless of what my trust or will says. Okay. Same thing with the life insurance. But if it's retirement account, I take that back. I'm sorry. As long as you have a named person, it does go to them and it doesn't go through necessarily the trust or the will. So this is something to be careful of, because sometimes people get confused. Well, then should I just name everything, put the trust as the beneficiary of all of my accounts? Well, depending on tax purposes and such, so that could be very different too. So this is an area where it really depends on the type of account we're dealing with, who it is that you actually want to receive the money, and how it's actually titled. If you can go back one thing, I do want to mention one quick thing on no beneficiary. if you don't list a beneficiary, and this happens often, it happens way more often than you think it does. People forget, or this happens a lot on 401k plans through your work, because a lot of times the company changes, right? Right now you have Fidelity 401k, and now they changed to E-Trade. Sometimes it requires a new beneficiary form and you didn't realize that, or you changed jobs and you forgot to do it. So regardless, when there's no beneficiary, it really depends on the type of account it is, on what kind of rules it will follow. I will say that a lot of times they also ask for contingent beneficiaries on various accounts. What contingent beneficiary means is if the primary beneficiary is not around, then will it go to? It's like the second tier of beneficiaries. A lot of times people don't list someone under contingent beneficiary, but I will say that it's probably a good idea to do so. And the one reason for that is, as strange as it may sound, there are times where someone may want to disclaim an account. So you have an account and you say that the beneficiary is this person. For whatever reason, this person may want to disclaim the money. It would go to the contingent. But if you have no one named as a contingent beneficiary, then what's going to happen? So there's a lot of planning opportunities, as you can see with the beneficiary. So make sure you talk to your advisor and CPA for this.
Yes, exactly right. Do you want to maybe jump in on this, how it's paid out as well?
Oh, I guess it's kind of two slides together in one. So same thing. If it's payable to a specific beneficiary, if it goes to a person, it's theirs. They can do with it however they want. What they need to do is, like the investment companies or the insurance companies, they are not going to know that a death occurred. So you would have to come, there's usually like a claim form, and you have to submit that a death certificate for that. If it gets payable to the trust, the money goes to a trust, and then the trustee will handle it. If it's a retirement account, there's a lot of rules that apply with retirement accounts, depending on if it's a pre-tax account, how planning may work versus a post-tax account. So you may just want to talk to your advisor about that.
Right. I mean, this part, like you said, a lot of planning opportunities, like what if the beneficiary, has a spending problem? What if they shouldn't get the money like right now, right? So a lot of things you can do to plan for this.
And the tax implications are different depending on who the beneficiary actually is, depending on the type of account. So
yes,
yeah, there's a lot of planning opportunity here. So don't forget that little tiny question on these applications.
Definitely. But for purposes of today, it's about after death, and obviously the main asset that most people have is the house, right? And what happens to this property if someone passes away? It really just depends on the title of the property. So, if you haven't checked who's on title right now, this is a good time to see, what does my deed say, right? If there is one owner on this account and they die, what's going to happen? It's probably going to go into probate. I mean, if you have like a house here in LA and Orange County, probably over $184,000. And if that's the case, it does have to go through that probate process. If you do have joint tenants, then if one person passes, it goes to the survivor. Without probate, usually you just have to do like an affidavit of death deed that's recorded with a death certificate. If you have community property, maybe it says it's community property, and you don't do any planning, likely it will go to the spouse. You can, with a will, say, oh, I want my half to go, somewhere else. You can say that as well. If you have something called tenants in common, this is a little bit different than joint tenants, because if one person passes, it doesn't automatically go to the other people on title. It will go to their estate. If that little, say it's like a third, if it's a third is over $184,000, not in a trust, it will probably go into probate. Then, of course, you can title your home or property in a living trust. Then, it's handled by the trust terms, no probate. We would have to record an affidavit death of trustee. Of course, if you have like a mobile home, I didn't really mention it here, you may have to contact the Department of Housing and Community Development. Those have its own rules. And I didn't really mention it here, but your property, like if it's a commercial property, maybe it's owned by an LLC, you could have like a life estate. So obviously this list is not comprehensive, but just these are really common things. I also want you to note that if you look on title and it just says something like, husband's name and wife's name, period. It doesn't say as joint tenants. It doesn't say community property, anything after that, then the default is tenants in common. A lot of my clients go through probate because of that. And that half, again, over 184,000 going through probate. So how do we resolve some of these? We need to record a deed or a probate order to change this ownership. Some of my clients who are kids and they, their parents passed a long time ago and they, never got around to doing anything. And now it's still in parents' name, 20 years later. Well, something that must be done, because if now the kids pass on, you could have like a double probate, right? So just to say, do things sooner than later. Capital gains, want to mention that because there are some taxes that you need to consider when someone passes away. If you're thinking about holding on to that property, you may want to get an appraisal, which is done at the date of death, as of the date of death, to get an extra step up in basis. So Yuri's going to mention that a little bit later. But if you are going to sell the property, you still need you might need an appraisal if it's going to take longer than maybe 6 to 12 months. If it's less than that, usually the selling date will be the valuation date. If it's, if you sell it way longer than when the death occurred, you might have to get an appraisal also to calculate that step up in basis. Also, there's something called property taxes. This is the tax that you pay to the county every year. Any of these might cause a reassessment, right? If it's a joint tenant, one person passes, it goes to the other. It's almost like you're giving, 50, say it's two people, 50% of the property to the other. Anytime there is a change in ownership, right? The owners change. The county is always like, oh, can I reassess this property? There's only a few exceptions. And you might have heard something called Prop 19 that happened, the new law that happened last year, which makes it a little bit harder to keep those low property taxes going. You also need to know that time is running, right? So as soon as a death occurs, there's like timelines. So we want to do things timely and file these exemption forms with the assessor so that you don't miss out on some of these exclusions. Okay. What about the things in your house, right? What happens to the furniture? What happens to the jewelry, the cars? It typically goes to whomever is named in the will or the trust, right? So you can say, everything's split 3 ways with my 3 kids. Or you can say, no, everything in the house goes to, whoever, my spouse. Usually it's the executor or the trustee who will decide whether to distribute that, sell it, or donate it. The trustee also has to preserve trust property, so they can even protect those assets. So that's something that I mentioned here. Have you ever heard stories where people come in and try to take everything from the house as soon as someone passes? Well, the executor, the trustee may have a duty to protect those. So they may be able to change the locks or get a storage facility or somehow preserve that from getting stolen, from getting taken by people who shouldn't take it. If there's something of value, like jewelry, collectible, something of higher value, you might have to get that appraised. If the trust says, all my assets to my 3 kids equally, it might not be fair if someone gets a diamond ring and then someone else gets a lamp, right? So you may want to get that appraised so that their values and their shares are a little bit equalized. Cars, that's a common question, determined by the will or trust, right? I usually just ask my clients, hey, is there a family member who wants that? And then maybe they take it as part of their distribution. Maybe they want to buy it. What's a fair price? The DMV has forms to transfer this title, but you should probably, whoever wants it, or if you're selling it, probably do that as soon as possible because it's still in the deceased name, probably in the deceased insurance. So if something happens, you can imagine, right, with the liability. So whoever wants that, usually just try to get that out and distribute it. Digital assets, right? A lot of people have Robinhood accounts now. They do everything on their phone. They may need to go, whoever's the next in line may need to go online to close this out, trying to get into the phone to transfer assets. Right now we're working on cases where the Apple ID can't get into it, so we might have to petition the court. So we're doing that as well. So if I know Facebook has something where you can name whoever's the legacy person, so just trying to get that all in order, always thinking about, okay, if something happens, like who's going to have access, right? I recommend maybe a list, a password list, or at least some kind of account, because if you go, like, who's going to know, right? There's also something called a gun trust. If you have firearms, right, you know how they're so strict with the laws and the regulations. So a gun trust is recommended if you have firearms to reduce that liability. If something happens to you, you have a trustee who is in possession of these guns. What if it goes off, right? And what if something happens? You definitely want to reduce that liability. There's also something called a pet trust. What happens if you pass and, who's taking care of the cats, right? Who's taking care of the dogs, or where do they go? Who's feeding them, right? So there's also something called a pet trust that may need to be made for the care of the pets. Okay. People ask me a lot about creditors, right? I have this credit card debt, who pays that? Do I have to pay that off, right? What if I'm owed, what if somebody owes money? Well, we have to give notice to the creditors. If it's going through a probate, there's usually a very specific special probate form that needs to be sent out. And then once it's sent out, they have a certain very limited time to pay it back. And if you don't pay it back, that's it. You snooze, you lose. If there's a credit card debt, people ask me, okay, well, is the spouse responsible? Maybe. I mean, if it was incurred during marriage time, they might, but I think it really depends on the card company if they really want to go after the spouse. Sometimes they do, sometimes they don't. Either way, they do get notice of, they should get notice of the death. Okay, and another question I get is, well, what if there's a mortgage? Can the family member assume the loan? Most of the time, yes. They can assume that and then just continue those payments. But again, depends on the mortgage company and like the situation with like who is on the mortgage. And if there is a reverse mortgage, which happens quite frequently, obviously they will want their money and you have to pay them back, or someone from the family can pay it back if they want to keep the house. But if no one can pay this reverse mortgage back, you might have to sell it, pay them back, and then whatever's left in the equity gets distributed. Car loans, I mean, they're still loans and we have to pay them off. If you can sell the car, great, and then pay that loan off. Or sometimes the dealer, return it to the dealer and then they can auction it off. And then repay the loan, and then whatever's left goes to the family. Student loans typically die with the person. Medical bills, especially like last expenses, right? They take a while. So just kind of monitor the mail, see what comes in. You can typically negotiate it down, and you do also have to send them notice. Medi-Cal, for those people who might be on Medi-Cal, the probate code does require special notice to be sent to them. And if they are in need of reimbursement, sometimes they can get some cost reimbursed through the probate, or they may have some reimbursement that they send to you, the family member, to get it paid. Funeral costs, typically, if you can't get access to the bank accounts or the trust account, then usually whoever pays it, and then they can get reimbursed through the estate, typically. The franchise tax board, back taxes, of course they want their money. So you need to give them special notice as well, so that if there's any taxes owed, that of course they need to get paid. Okay, well then who is actually going to get the money, right? Who is the next in line? Who's the next of kin? If you have a trust or a will, obviously there's some planning that was done beforehand, and the assets are distributed per this will. And it's your money, right? You don't have to give it to your kids, or you don't have to give it to your spouse. You could give it to whoever you want to, if it's something that's within your control. And you do that by writing it down. Of course, we know in California, if I just tell you, oh, everything goes to you orally, obviously that will not fly. You need to write things down, it has to be written. We also have to consider, was there a premarital agreement, prenup, Was there a postmarital agreement? Sometimes that could affect how assets are characterized, right? Is something community property? Is something separate property? It matters at death time because it's distributed a different way. And then, of course, who was named as a beneficiary on these accounts, right? We just talked about that. Whoever's named, that's how it goes. And if there's any joint tenants, just whoever's a surviving joint tenant. Now, if there's no will and no planning, then what happens? So this is the default law of California. If something, if you're married, it would go to your spouse. If it's considered community property, no planning done, it all goes to the spouse. If something's separate property, right? Maybe you had some assets before marriage, maybe you got an inheritance, right? Or maybe you just, by this prenup, you decided what was separate and what was community. If you only had one child, it goes half to spouse and then half to the child. If you had 2 or more children, third to spouse, 2/3 to kids. If you don't have a spouse, then it would go to children, no children, grandchildren, no grandchildren, parents, then siblings. Step siblings could apply here, right, in certain circumstances. Siblings, children, which are the nieces and nephews, aunts and uncles, and cousins. There are a lot of different, exceptions and different rules to this, but generally speaking, this is the default distribution. And Yuri, maybe you can jump here and just talk about some taxes to consider when a death occurs also.
Yeah, so when it comes to filing status, generally, if you're married and your spouse dies, in the year of death, your filing status will be married filing jointly. If you have dependents, for 2 tax years after their death, you can use the qualifying widow filing status, which is basically where you get to use the same tax rates and standard deduction as married filing jointly. If you have a living trust, then the trust will become irrevocable, and it may need to get an EIN or tax ID number, which you can get from the IRS. The trust may also need to file tax returns. It just depends on the type of the trust and what kind of activity or income it had. There may be an estate tax return due if there were assets held in the individual's name outside of the trust. Step up in basis. Appreciated assets are going to get a step up in basis. Depending on the type of asset, you might want to get an appraisal done of the value of the property as of the date of death. So like for homes or rental properties, jewelry, collectibles, things like that. This is really important, especially if you're inheriting a rental property. Since if you're going to continue to rent out the property and it's going to have rental income, the increased value could increase the amount of your depreciation expense that you could deduct against the income. So definitely, if this property is going to be rented out, then you need to get an appraisal done. There may be a property tax reassessment, like Sophia mentioned earlier. There's some exemptions, so you just need to make sure, see if you've applied or see if you qualify for any of them, and then make sure to file those requests on time. There's no death tax in California. There is federally if assets were over about $12 million. This $12 million number is adjusted for inflation each year until 2025, when it's supposed to drop back down to like $5 or $6 million unless Congress steps in. This is one of those numbers that seems to change with every presidency, so it is kind of a moving target.
Right, and if you're married, then that individual exemption rate is now like 24 million and under. So usually right now, tax planning, not really a big deal. It's more about like writing down your wishes and avoiding this probate. And speaking of probate, what if there was no planning done, right? So if you didn't plan anything, no will, no trust, likely you're going to be in probate. And you may have heard of probates to be avoided, for all the reasons about planning, but really, if that doesn't get you, then look at how much it's going to cost, right? If your assets are about $1 million, like you got a house in LA, no, see, I mean, it's probably going to be around there, right? With other assets, bank accounts, everything. So let's just say in this example, it's $1 million, $23,000 in attorney fees, right? Plus $23,000 in administrator fees. That's the one who's going to take care of things. plus court costs and an hourly rate for anything unusual, we're looking at about $50,000 for probate. I mean, if that is not enough of a motivator to like get a trust done, right? But, and if you know, sometimes my clients only have like one house in this estate and they want to keep it. Okay, well, who's paying the cost of court fees and attorney fees and other fees? Like, how is that getting done, right? If they can't pay for that, they might have to sell the house or get a loan or something. The executor or the administrator handles the estate. Executor is with a will, administrator is without a will. And probate is usually taking about 1.5 to 2 years right now in LA and Orange County. So that's a long time for the family to get their proceeds and really to go through that stress of going to court. One thing to note is anything that's filed in court is a public document, right? So, you know, people are going to know like the assets, they're going to know your property. It's anyone can just go to the courthouse and find that information. I guess one good thing about probate is that it's under court supervision, which means that the court does review everything, which is good because you do have someone kind of overlooking and you do have to file things and kind of move that along. But, you know, again, it costs a lot and it's very, it takes a long time. So then the alternative is maybe a living trust. And what if there was a trust then? What happens at the death? Well, whoever you named as a trustee, they are the ones that are going to be handling the trust assets. It's out of court, which means that it's private. You know, when the COVID pandemic happened, the courts, probate courts were shut down for a while. So all of my probate court clients were just kind of at a standstill. But the trustees and out of trust clients were able to just conduct business. The cost to set up and maintain a trust is typically lower than a probate typically. It's customized. You can, you know, say who you want to give it to, right? You can set up when people get their distributions, maybe they don't get it, maybe you keep it in a trust, a lot of different types of trusts. And the cost to administer this trust, it really depends. So don't think like, oh, I set up this trust and then that's it, that's all the costs. I mean, obviously, if someone passes, someone's got to carry out this trust. So there could be some cost there, and it really depends on what needs to be done. But because it stays out of court, sometimes it could be faster to close than that 1.5 to 2 years that a court typically takes. Here is some other things to consider, right? So obviously, if someone passes, you're going through a tough time and you might feel like lost and it's the first time you've ever gone through something like this. That's why you should definitely seek a consultation with an attorney, your financial advisor, an accountant, people who can guide you. Especially if you're a trustee, you have a lot of duties. There's things that you need to do. You have to send out notices, right? So it would be very beneficial to talk with people who can assist you during that time. Also important to get organized, right? Create a chart of all the assets, like what's happening, what's the timeline. I don't want you to miss like a deadline or anything. Talk with a real estate agent if you're thinking about selling the house or, you know, what you think they would cost, if it needs to be fixed up. They may be able to help you with what's the market conditions, right? Also, if you are considering a house, I mean, right now the market is great. What's going to happen, you know, if it goes down and you sell it at a low point, right? Will all the beneficiaries get mad? Possibly. So something to talk with an agent. Also, you know, talk with a therapist and a grief counselor. This is like one of the toughest times to go through, right? And you know, you want to have proper time to grieve, but at the same time, you know, life goes on and you have things that you need to get done. Maybe it's good to have someone who you can talk with through these difficult times. If you have a good relationship with your family members, or maybe if it's just kind of so-so, but hey, at least if you can talk it out, communicate, everyone get on the same page, set timelines, see if you can agree on the items first, right, before coming to an attorney. That would be very helpful to smooth and get the process going. But, you know, some families don't work like that. And that's why you have attorneys and advisors to kind of assist. If you have to organize the house, I hear a lot where like my parents were hoarders, right? Don't feel like you have to do everything on your own. It's a lot to do. You can take your time, right? Organize the house. You can delegate some of the work. You can get people to help you. It's a lot and it can be overwhelming. But keep in mind, if you're a trustee or an executor, there's some things that cannot be delegated to other people. Obviously, you're put in that position to make decisions. So while you can get some help, you may not be able to push everything off on them. And for those people who do help you, maybe they get reimbursed for their services and their time. And most importantly, don't make any big rash decisions like immediately after the death, right? I mean, just take some time, let things settle, see, kind of think about the consequences before you make any of those big decisions. And then lastly, what can I do to prepare, right? We've just gone through what happens when someone passes. Well, how can I prevent some of these issues that could arise? Well, obviously, establishing or reviewing a living trust, a will, a power of attorney. Anyone over 18, definitely I recommend a will, powers of attorney for finances and health, right? What if you're alive, but you become incapacitated? Who's going to have access to this bank account, right? Who's going to sign the deed, right? And we're doing these documents, as you can see, for your family members who will need these to go to the banks, right? And if you don't have that in place, they will have to go to court, which nobody wants to do. Something you can do now is ensure that your assets are titled correctly. Remember what we talked about, naming beneficiaries, right? There's some things that we need to watch out for is like a minor child named as a beneficiary. So go ahead and check that. Have an advanced healthcare directive, right? Make sure to inventory all your documents and keep them in one place. Now, what's the use of doing a trust and a will if nobody can find them after you're not here, right? So make sure you tell your next in line where it's located. If you have it in a safe, I mean, make sure they have access to the safe or they can get it so that they know where these documents are. Digital assets, make a list of passwords or at least something where someone else can eventually access that. Name an agent if you can. If you want to, you could do some funeral planning. Now, if you're, a lot of my clients are, what, they'll decide it and that's fine, but it might be a lot for them to decide at that moment. So sometimes pre-planning that, pre-paying those arrangements could be a good idea. And at the moment might really be a benefit for those family members who are going through that. So, buying a plot, getting funeral insurance, things like that. Set up life insurance if you have dependents, if you have a mortgage, if you have assets that are not liquid, they're like real property, right? If you pass, think about it, your stream of income is also going to like who's going to pay this mortgage for like, your 8-year-old kid, right? So we life insurance, use that as a tool, talk with your advisor, see how much is appropriate. And then lastly, get your team in place, right? Write it down so that when something happens, the next in line, they know who to talk to. They already have it all set. I ask my clients like, oh, who's your accountant? They're like, oh, I don't really know, right? So it would be nice if we already had a team, someone who you've already worked with, who you know and trust, that would easily be able to help your family members. And that's it. Donna, you're on mute.
Oh, sorry, I need to unmute. Look at that timing. I was just commenting that we're right on time. That's pro status right there. And I don't think we have any questions that came in. Obviously, a lot of the questions are very specific to your specific situation. So if there are questions, feel free to email Sophia for them. Thank you so much, Sophia, for your time and expertise today. You've actually been a very integral part of our team, but so often our topics are dominated by tax and financial planning. So I'm really glad that we were able to spotlight you today and your expertise, especially on a topic that we will all encounter someday, hopefully far, far, far into the future. And thank you very much to all of our attendees. As usual, we strive to provide content that's worthy of your time, and we hope that you continue to find these webinars useful. Reminder that the recording is available on the website, usually by the end of this next week. And our next event is going to be on Friday, August 19th at noon. We're still finalizing the content for that webinar, so stay tuned. And we hope everyone enjoys their summer break, and we will see you soon. Thank you very much for attending.
Thanks, everyone.